Hundreds of people gathered outside the home of former President Jacob Zuma, defying level 4 lockdown regulations that prohibit all gatherings in the first place. When Zuma addressed his supporters and the media later, he said he could not take responsibility for their actions. And people are angry, he said, because the Constitutional Court did not do the right thing when it sentenced him to 15 months behind bars for contempt of court. Zuma was once again critical of judges and suggested that the Constitutional Court judges were conspiring with the chair of the State Capture Commission, acting Chief Justice now, Raymond Zondo, against him. Last night he addressed the media and made several claims, one that judges have been biased against him and subjected him to Zuma laws. He mentioned a female judge and said everyone was shocked when she issued an arrest warrant when he was too sick to appear. He says she was part of the Constitutional Court, which has subjected him to detention without trial. He says he's a victim of a travesty of justice, and again saying he's been sentenced to jail without a trial. Let's discuss. So we're joined by Associate Professor in the Faculty of Law at the University of Johannesburg, that's Professor Tseli Phooko. We're also joined by constitutional law expert Advocate Michael Osborne and political commentator Makhosini Mgitywa. Thank you all for being with me tonight. Let me start with you, Professor Phooko. It sounds like a new argument to me. I haven't heard this, if he said it before. The former president saying he's been sent to prison without a trial. So this is about the Zondo Commission being allowed to access the Constitutional Court rather than the contempt issue going through the lower courts. Does that claim have any basis for you?
Thank you very much for hosting us, and good afternoon to the panelists as well as the viewers. Well, I must agree with you. That is for the very first time that argument is being raised. Remember that he did not take any part to the proceedings before the Constitutional Court. With that said, I am convinced that it's a legitimate claim and it's a fair argument that he has been summarily incarcerated without due process, and that goes counter the provisions of our Constitution.
All right, Advocate Osborne, do you want to comment on that?
I'd say I don't agree with the professor for the following reason. There's a very long chain of precedent that one of the circumstances under which a person can in fact be summarily convicted and punishment is precisely for a contempt of court. This is the standard practice. The precedents are very well established. It's true that these are extraordinarily unusual circumstances, not only here but internationally. I cannot think of a single precedent anywhere in the world where a former head of state has been sentenced to jail for contempt of court. But no, I don't think this is an especially controversial decision. And if you read the decision of Justice Nkandla, I think she's extraordinarily powerful in her statements, in the statement of these unusual facts and in her analysis of the relevant legal precedents.
Mr. Mgitywa, what do you think of this as a political move? Because, I mean, if you listen to him yesterday, he actually suggested that he's been harassed more by the current government than he was, or any black person was harassed by the apartheid government. Quite an incredible claim, saying that the case against him has been dismissed and returned, and then using that very emotive sentence that he's now being subjected to detention without trial.
Look, good afternoon to everybody. I think what the game that former President Zuma is playing is one of playing to his base and with the hope that it is this base, this support base, that is going to protect him. And we saw this the weekend. Clearly, it was playing itself out. We started hearing dog whistle messages that people must go there to defend Nkandla. And we saw, visuals on social media, people bearing arms, automatic rifles, going to Nkandla, which meant that, one, he was not going to go to prison, and that those people were going to make sure that he doesn't go to prison. So in order for him to sustain that, there are talking points that he needs to give to these people so that he can galvanize that base, cultivate it, energize it, so that it's out there ready to defend him. And I think this ought to be taken seriously, more seriously than it is taken seriously. On one hand, you see these people walking around, not all of them wearing masks, no social distancing. So these are people who do not care so much about their lives, and you can't expect them to care much about other people's lives, especially when they're carrying arms and when they clearly show that they are not going to allow the former president to be arrested. So I think this requires cool heads. There are two extremes on this matter. You've got one extreme of people who are saying that Jacob Zuma must be taken to prison. If people try to stop the police must shoot them. He must go to prison. If he dies in prison, that's fine. You have on the other side people who are saying that he did nothing wrong, nothing should happen to him. Those are people who are actually calling for impunity. And I don't think that we should be swayed by any of these two extremes. I think the solution is somewhere in the middle. We have a reality here that there is a possibility of political violence, especially in KwaZulu-Natal and somewhere in Gauteng as well. And even if just one person dies, that's one person too many. The president has a responsibility to make sure that he protects all lives. And that also means that we must find a solution which is not going to lead to bloodshed.
All right, I want to talk to you about this further, and advocate and professor, please stay with us. But let's just bring in now Nkandla Maseko, SABC reporter, and you can give us something of what we can expect in Pietermaritzburg tomorrow, Nkandla, in terms of who could be outside the court and what will be underway inside the court.
Essentially, Francis, tomorrow that you mustn't anticipate that there will be a fanfare outside the Pietermaritzburg High Court as the sitting will be taking place virtually. We've just seen a directive coming from the Constitutional Court going towards the Pietermaritzburg Regional High Court saying that the sitting will be virtual. There will be no politicians lingering around the Pietermaritzburg High Court. There will be no trucks that will be used for those politicians to speak to their supporters, and there are no buses organized to ferry ANC members and supporters to go to the Pietermaritzburg Regional High Court to support former President Jacob Zuma. We do know and understand that the Helen Suzman Foundation has filed its responding papers to the Regional High Court opposing this application of a stay by the former president on his incarceration by the Minister of Police and the Police Commissioner Nkandla Stole. So essentially, tomorrow will be a virtual sitting, and there will be a feed sent out to all media houses, failing which, if there is a change of plan, then there will be a sitting at the Pietermaritzburg High Court, and everybody involved in this case will have to converge upon at the court. But at this point in time, the sitting will be virtual. We do know that the State Capture Commission of Inquiry is opposing this interdict of a stay of execution of the arrest of the former president, and also the Helen Suzman Foundation, the office of the president and the minister's office have opted to stay out of this particular case and said they will abide by whatever decision is made by the court.
All right, thank you for that update, Nkandla Maseko, who will be following that for us. Let me come to you, Advocate Osborne, if we can bring him up on the screen. There is a legal argument going on right now about whether or not the former president is in contempt of court for not handing himself over. Then we have this application for a stay of arrest. It does sound like the police are basically going to wait and see what the outcome is from that Pietermaritzburg hearing. You've got the court papers. What can we expect from court tomorrow, Advocate Osborne?
Well, we can expect the Pietermaritzburg High Court to listen very carefully to the parties' argument. And I would say it's always very difficult to predict what a court is going to do. You can't anticipate whether the parties may raise new and unanticipated arguments. However, if it's possible to make any predictions at this point, it seems very unlikely that the court tomorrow will come to Mr. Zuma's assistance. And I say that for two reasons. First of all, although in principle a high court does have the capacity to grant temporary relief to persons under its jurisdiction, this is an extraordinary circumstance where the order for the arrest comes from the highest court in the land. And many high court judges are going to be very careful indeed, about purporting to exercise some kind of restraint over the implementation of the Constitutional Court order. That's the first thing. Secondly, Mr. Zuma's legal representatives tomorrow are going to have to try to persuade the High Court that they must be granted stay of arrest because, amongst other things, there are reasonable prospects of obtaining a rescission at the Constitutional Court next week on the 12th. Now, as I understand the arguments, there is, as a purely legal matter, about something akin to 0% of the Constitutional Court actually accepting the argument that its own decision must be rescinded, simply because rescission is a very, very difficult form of relief to obtain. It's not like an appeal where there's going to be a full adjudication of all of the arguments. The Constitutional Court has to be persuaded that what it decided in terms both of the conviction for a contempt and the sentence was fundamentally and objectively wrong. And I don't think this has ever happened before, and it's most unusual, or it's most unlikely, that this will happen in this case.
Yeah. Professor Phooko, do you want to come in there? Dali Mpofu, the former president's lawyer, last night saying there's a gap, so they don't know, I guess, if the arrest order is suspended or not. He says the Pietermaritzburg High Court should make a ruling on that. How do you think it'll go tomorrow? And then regarding the Constitutional Court, Michael Osborne is saying, the rescission order will be hard to get. Some people say that the court has even been biased, not against Zuma, but towards him by even allowing this application to go ahead. Your comments?
Thank you. Let me start with the High Court. I must agree with my colleague that once a matter is basically in the hands of the court, it's like you are playing a dice. It becomes very difficult to predict. But a closer reading of the rules of the High Court, particularly Rule 45, it indicates that, the High Court has the power to stay any order. I would interpret that any to include even the orders of the superior courts, that is the Constitutional Court in this matter. So the matter is well before the court, and I suspect, I predict that as much as this is an unlikely, an unusual case, it doesn't mean that we should deviate from the criminal processes or the rules of the game. So the arguments will be heard tomorrow, and my predictions are that there will be stay of an arrest. Then moving to the Constitutional Court, the arguments are quite interesting reading them from where I am. But I must also indicate that it is not the first time that the Constitutional Court has kind of, relooked at its orders and kind of, amended them in a manner that it deems just and fair. So as much as this case, is unique, has attracted a lot of public attention, the court has not hesitated in the past to relook at its judgment. And the difficulty, the main problem...
Professor, can I ask you for a legal explanation here? Because apparently it only can change its own mind if there are significant new factors in the case. And the former president is talking about being elderly. He's talking about COVID. So these aren't necessarily new. And he also didn't take the opportunity when he had it to bring those arguments up when the Constitutional Court gave him that opportunity.
But that now takes us to the powers of a civil court insofar as the contempt and the punishment that ought to be imposed on an uncomplying or reluctant witness. In this matter, in my view, the power of a civil court or the constitutional court can only go insofar as to try and coerce that particular person to go and appear before the commission. And the court did try to coerce the president by issuing the first order that he must go. But that coercion did not provide any good results. So the moment now the court issued a punishment, in my view, it totally moved now into a criminal process terrain. And that is a matter that now ought to be dealt by a criminal court. About 5 days ago, a similar matter presented itself before the Supreme Court of Appeal. And the Supreme Court of Appeal was very careful. To that extent, it referred the matter to the Director of Public Prosecutions to attend to it. But in this particular court now, we are seized with a court which embarked in a criminal process and finalized it without following a due process. That's where my difficulty is in following, the Court judgment. And my prediction here is that let us wait for the judgment, and I am highly convinced that the Constitutional Court might relook at its decision.
All right, this is very... Yes, you can, because you disagree fundamentally. Go ahead, Advocate.
Yes, Professor may be right that there's an argument to be had as to whether, in the course of civil matter, coercive punishment can be imposed. He may be right on that. And if one looks at the minority judgment of Justice Theron in the Constitutional Court, I think she raises some matters that are arguable. She may not be right, but I think those are good faith arguments that can be met. The problem here is that Justice Kampepe, with the majority of the court, considered that very question, the doctrinal question, which distinguishes between civil and criminal processes. She considered that at great length only 10 days ago. For the court on a rescission application to change its mind, not on a question of fact, but on a question of doctrinal law, a couple of days later is, I think, entirely unprecedented, especially where the applicant had every opportunity to raise that argument and failed to do so.
All right. Thank you for that. And then, of course, there will be the claims that the Constitutional Court may or may not have bent to political pressure. Let's bring in Mr. Mgitywa here. You were saying earlier, sir, that there should be some sort of solution here. Cool heads should prevail. We shouldn't go to either extreme. Isn't this a matter where the courts should decide what should happen and the rest of society should respect that?
You're quite right. But, the judges of the Constitutional Court are not elected by the people. The executive is elected by the people. I think the executive needs to look at what solutions can be brought forward in a situation like this. Because, I don't think that judges of the Constitutional Court could have predicted that what happened in Nkandla at the weekend would have happened.
But explain to me what solutions you're referring to, where the NEC has to deal with this without undermining the courts. How would it work?
Look, let's look at the precedents that we have elsewhere on the continent and other parts of the world. Not very long ago, South Africa hosted Jean-Bertrand Aristide of Haiti. Right? He was removed from that country because his presence there was causing a problem. In Zimbabwe, you have Mengistu Haile-Mariam from Ethiopia. He's been there since 1991. So there are political solutions where a leader sometimes is asked to leave the country because his presence in the country is causing conflict. There is also another option that could be followed, that the president can exercise his constitutional rights. The lawyers with me, the panelists will correct me if I'm wrong, that he could commute the sentence that was given to the president. But looking at it as a political consultant and looking at the situation in KwaZulu-Natal, I think the enforcement of the order of the Constitutional Court could mean that the police must use deadly force in order for them to be able to extract a former president out of his house and send him to jail. And I think that, for me, is akin to burning the house to roast the pig. We have to find a solution that does not include political instability or political violence or any loss of life for that matter. And the situation as it stands in Nkandla, it gives you a sense that a standoff is about to take place. So there has to be a solution. And I'm glad that the National Executive Committee of the ANC is getting involved in this, because this is their creation anyway. This is their member. This is their deployee. They sent him to be the president of the republic. He set up the commission that he himself now is defying. So this is the matter that falls squarely within the realm of the ANC, and the ANC must provide leadership in this respect.
Well, before we leave you with the political side of things, what do you think about the ANC handling of things thus far? The National Executive Committee was meant to meet over the weekend, and they halted that. They stopped the work of the committee because of what was going on in Nkandla. Was that right, or are they not sort of augmenting what is happening at the former president's home?
Look, they must be commended for that decision. That was a sound decision. It was a decision in its intentions. It was about saving lives. It was also making sure that we don't leave a situation where people, armed bandits, are saying that the state cannot enforce the court order. But them going there, it shows that they're trying to find a solution, bring close the people who are standing there, standing in confrontation with the police, but also to talk to the former president. The former president of the ANC, to say there has to be a better way of handling this. We can't have a situation where we have to start with that super spreader event, which means that for days and weeks to come, we are going to have a wave of infections rising out of Nkandla, which means a longer lockdown, which means suffering for poor people. There has to be an intervention in this respect. We cannot leave things the way they are.
All right, Professor Phooko, I'd love to hear your thoughts on what Advocate Osborne was saying earlier, that it would be quite extraordinary for the Constitutional Court to change its mind when it's looked at all the facts, not a short while later. And wouldn't it be accused, what I was saying earlier, wouldn't the Constitutional Court then be accused of giving in to political pressure, which will raise a whole lot of problems for this country again?
Well, I must agree with Michael that, well, a rescission application, because you basically trying to say, listen here, you were wrong on the law and the facts and so on. So it might be a little bit a huge, benchmark to meet. But judges are human. I mean, we do accept that there is a huge, political pressure here. I don't think that if one is changing a decision, that has to be in line with what the prescripts of the law are saying. That would be necessarily and could be classified as an unjust pressure.
Okay.
The rules of the law requires that no matter how extraordinary the circumstances are, they should still be adhered to. That would be my input.
Advocate, you can have the
say
last word. Yeah, you're going to have the last word. And I also want you to just pick up on something that one of the Jacob Zuma supporters said yesterday. She said this is insensitive. He's he's of advanced age. Sending him to prison is insensitive, especially considering the role he played in liberating the country. So my question to you as well is, should the court be considering sensitivities like that?
Well,
Advocate Osborne.
I'm sorry. Yes, on the question of Mr. Zuma's age, there are options in terms of his health. The Department of Correctional Services has hospitals, has special facilities, and one would expect that the department would, as always, as with any prisoner, take into account Mr. Zuma's needs, his advanced age, etc. So certainly that has to be taken into account. It's not, however, the function of the court to make that particular decision. It's an administrative decision to be taken within the department. But secondly, may I say this, the fundamental legal principle at stake here is equality before the law. That's very well established in our Constitution, and that has to be vindicated at all costs.
All right,
Now,
Advocate, I have to stop you there because we're running out of time, but I think you've made it clear where you're going with that argument, and thank you. I've really enjoyed this discussion with all of you. Professor Tseli Phooko, Associate Professor of the Faculty of Law at the University of Johannesburg, Advocate Michael Osborne, who is a constitutional law expert, and a political commentator, Makhosini Mgitywa.